Welcome to Don't Get Slapped Around in Civil Court. How to Recognize and Handle Anti-SLAPP Issues. I'm Lori Cripp-Martin, the Vice Chair of the Beverly Hills Bar Association Litigation Section. I'm a certified family law specialist. I'm delighted to introduce today's speaker, Brendan J. Begley. Brendan is a shareholder at Weintraub Tobin. In litigation, Brendan has worked on class actions and managed entire cases, including conducting witness interviews, preparing and responding to written discovery, arguing related motions, taking and defending scores of depositions, while prevailing on numerous anti-SLAPP and dispositive motions. He has mediated many cases and second-chaired trials to successful verdicts. At the appellate stage, Brendan has handled both briefing and oral argument before all appellate courts, from the California Court of Appeal to the U.S. Supreme Court. And now let's get started. Take it away.
Thank you, Lori, for the very kind introduction, and thanks to the Beverly Hills Bar Association for giving me this opportunity, and thanks to all of you who are joining me today. I want to make sure, let's see, you can all see my screen.
Yes.
Okay. I want to start with a standard disclaimer. I'm going to entertain questions once I get through, maybe halfway through the presentation, where I kind of give you all the nuts and bolts about how anti-SLAPP works and things to look out for. And after that, we'll go into some hypotheticals, but it would be unfair for me to launch into the hypotheticals without answering some of your questions first. And so as long as it's understood, like all these MCLEs, right, that I'm not giving you specific legal advice about a particular case, but we're just talking about hypotheticals to kind of illustrate and promote understanding of how this area of law works in general. So to get that started, my vanity compels me to talk about me for a little bit. So you know why I might be somebody who knows a little bit about this area of law. When I was before law school and during law school, I worked as a newspaper reporter, and I wrote some newspaper stories about a fire department that was making a transition from kind of a volunteer organization to a professional organization. And, they had some growing pains along the way. But this fire department was used to just nothing but positive publicity, like they rode in the 4th of July parade and the Dalmatian sat on the truck and didn't bark or what have you. And so when they started, getting some kind of critical press from me, they got really mad and they hired a lawyer who went to a law school that taught him a really good lawyer knows how to cuss, how to yell, and how to insult, and how to try to intimidate and bully. And so like he threatened me consistently multiple times with all kinds of lawsuits. And I was what you call a stringer. I wasn't a full-time employee for the newspaper. I was trying to prove myself. So I was like an independent contractor. They bought my stories for me for like $1 an inch. Even back then I would have starved if that's the only job I had. So I was kind of frightened. I couldn't afford to hire any of you or myself as a lawyer to defend against a lawsuit like that. So I had some sleepless nights thinking about, did I corroborate that? Do I have facts to back it up? Did I have any typos if they're going to sue me for in my article? But a judge I clerked for nicknamed me Babylon Brendan, so I wasn't going to back down. I kept on writing my stories, and, he didn't sue me. My stories were accurate, and, they didn't like them, but so what? After I got out of law school and I started practicing, I discovered the anti-SLAPP statute. And oh my goodness, I thought, if this statute had been around when this guy was threatening me, I wouldn't have lost 1 minute of sleep. I still would have, been careful to make sure my stories were accurate. But I wouldn't have worried, because I would have said, well, go ahead and sue me, because if you sue me, we're going to file an anti-SLAPP motion, and you're going to pay my attorney's fees for defending against your strategic lawsuit against public participation. That's what a SLAPP is, a strategic lawsuit against public participation. So anyhow, what I really love and adore about this statute, ever since I discovered it way back in like 2000, 2001, was that, and remains that, it's an anti-bully statute. It really, if you've been able to use, and if you're able to use an anti-SLAPP motion successfully, you and your client are going to be thrilled. If you find yourself in the crosshairs of a solid anti-SLAPP motion, you're never going to forget it, and you're going to suffer some discomfort. And so my presentation here is really to help you all see not only how to bring an anti-SLAPP motion or what kind of situations you should file an anti-SLAPP motion, but also hopefully, and maybe even more importantly, how to draft your complaints, your petitions, your legal actions in a way where you don't get hit with an anti-SLAPP motion, or at least if you do, you knew it was coming, you got your ducks in a row, and you'll be able to deal with it appropriately. So me, enough about me. What do you think about the fact that when I discovered this statute, I found a way to expand it from the classical kind of defamation kinds of claims and infliction of emotional distress claims into employment law. And I got a published decision out of it in 2007, Virgos v. McNeil. Well, you might think as much of me as the woman in the picture thinks of that guy. So let's move on from there, and I'll tell you what's more important is not so much what I did, but how to recognize claims that could trigger and make you vulnerable to an anti-SLAPP motion, or claims that are filed against your client that you can attack through an anti-SLAPP motion. And so, that's the two things I really want to focus on is, how to avoid pleading a claim that can get you in trouble, and how to recognize a claim that can lead you and your client to a really good outcome at a very early stage of the case. So let's focus on some things I'm not going to talk about in this discussion. I'm not going to focus too much on whether or not it's good policy. As you can tell, I'm a bit of a fan because I found ways to use it effectively, not only in filing anti-SLAPP motions, but listen, my colleagues here at my firm come to me and say, we're thinking about drafting a complaint. What do you think about this? Because they've heard me talk about anti-SLAPP and they have an idea of what can get you in trouble. And we've been able to draft complaints that have, avoided anti-SLAPP scrutiny. So I'm not going to talk about whether or not it's good policy. I tend to think it is, but at the same time, I acknowledge there's been a lot of misuse of it out there. And so, we're not going to go into a detailed analysis of the exceptions to the anti-SLAPP statute, but they're out there. The anti-SLAPP statute is section 425.16 of the Code of Civil Procedure. The exceptions are just one page over in section 425.17. So if you think you have, a potential anti-SLAPP exposure, or you might be looking to file an anti-SLAPP motion against something filed against your client, turn the page to 425.17, have a look at those exceptions. I'm also not going to talk about slapbacks, except to tell you basically what they are. There's a lot of misunderstanding out there about what a slapback is. But if you file a SLAPP lawsuit against somebody, say malicious prosecution, well, let's say anything, any kind of lawsuit that you file that turns out to be a strategic lawsuit against public participation and it gets bounced out by an anti-SLAPP motion, that anti-SLAPP motion got the other side their attorney fees, and that's it. But it's possible, in fact, even maybe likely, that because your claim got thrown out by an anti-SLAPP motion, it was not only anti-SLAPPable, but it was also frivolous and therefore subject to malicious prosecution liability. And so that means the other side can file a lawsuit against you and your client alleging malicious prosecution. And after everything I tell you today, if I didn't tell you about slapback, you'd think, a malicious prosecution claim is per se protected by the anti-SLAPP statute. If somebody files a malicious prosecution claim against me, I can file an anti-SLAPP motion against them. Well, that malicious prosecution claim in the scenario I've described is a slapback. It follows a successful anti-SLAPP motion, which is really going to decrease your ability to anti-SLAPP that malicious prosecution claim. So that's what a slapback is. A slapback is a malicious prosecution claim that follows a successful anti-SLAPP motion. All right, so we're not going to go into a lot of detail about that. We're not going to assess claims that don't enjoy prong one protection because they the speech or petitioning activity was illegal as a matter of law. There's a California Supreme Court case that discusses this, Flatley v. Morrow. And by the way, I want to say all the cases that you see in the slide presentation are summarized in the handout material, so don't feel like you have to scribble down case names before I run to the next slide. They're all in there with a little synopsis. So Flatley v. Morrow, Flatley was the guy, Michael Flatley, who was in Riverdance, that popular Irish step dancing performance. I had a cousin who was the only person in the world who told me when I was younger she thought I looked like him. Everybody else wants to say Conan O'Brien. I'd rather be Michael Flatley, but all right, there's that. We're not going to talk about, these kinds of claims. The Flatley decision is very I don't know, dense, but it covers it quite a bit. The takeaway is it's very rare that you're going to be able to say something isn't protected at prong one because it's per se illegal. You're going to understand more about that as I get further in the presentation, but we're not going to talk about that little wrinkle so much. We're also not going to do detailed discussion about anti-SLAPP motions in federal court. You can file them there. There are some wrinkles to that. You don't get the discovery freeze and some other stuff, but anyhow, you just need to know you can do them there too. Also, some things we're not going to talk about. I'm not going to cover detailed how-tos. How do you file it? I'm not going to do what to do's if you get hit with one, except I'm going to say right now there's two prongs. Don't make the rookie mistake of just arguing prong one, this isn't protected activity. Take the second step and show that your claims have a likelihood of success. You're going to hear me talk about the two prongs quite a bit, so that's an initial preview. We're not going to do what abouts in connection with attorney fees. If you win an anti-SLAPP motion, you get attorney fees. If you lose, the other side is only going to get attorney fees if your anti-SLAPP motion was frivolous. So I'm not going to go into that. How do you file the motion? What kind of declaration do you need with it? Does the lodestar apply? We're not going to go into all that. We're also not going to do detailed O&Os about the discovery freeze, although I am going to talk to you about it a little bit to emphasize why you really should care about this statute and anti-SLAPP remedies. We're also not going to talk about the immediate right to appeal. That's probably one of the more controversial things about anti-SLAPP. That's where most judges really bristle as the immediate appeal. We're not going to talk about whether or not that's good or bad. You just need to know that immediate appeal can have consequences for your case. And let's talk about why. Let's first talk, though, about why do we even have this law? Well, the very beginning of 425.16 says it's because there's been a disturbing increase in lawsuits brought to chill free expression. The classic kind of anti-SLAPP, a classic kind of SLAPP case that I suppose motivated the anti-SLAPP statute would be somebody wants to build some kind of thing in your neighborhood, some kind of commercial enterprise. And maybe it pollutes, maybe it's going to diminish the ability of small businesses to stay afloat. Maybe it's going to have environmental impact, maybe it's going to have noise pollution, who knows? Lots of different people might want to circulate petitions against the building of this and go to the zoning commission and go to the city council and go to the board of supervisors and say, we really don't want this in our neighborhood. And so the commercial enterprise goes out and files a lawsuit, not because you've really defamed them by circulating this petition activity, not because you've really caused them any financial damage, but just because they want to shut you up. They do not want you to cause any problems with this thing getting developed. They don't want you to jeopardize it at all, even though everything you're doing to jeopardize their project is First Amendment protected. They can still sue you for it, and then you have to march all the way through discovery, maybe a demur at the beginning, a summary judgment motion, and then possibly a bench or a jury trial. That's, I don't have to tell you all, that's very expensive. We're talking about easily six figures, right? To march all the way through that, high six figures, I think, in a lot of cases. So, a person who's engaging in that kind of petitioning activity is likely going to say, Uncle, I'll settle with you, big company, dismiss your lawsuit against me, and I promise I won't go circulate these petitions anymore. And so for the cost of, nickels and dimes to them, they've squelched a lot of free speech and petitioning activity. So the legislature passed this statute, and it says if somebody sues you for something that, compromises your free speech and petitioning activity rights, you're going to be able to file an anti-SLAPP motion at the beginning of the lawsuit to test how strong of a claim it is. And if it's not strong, the court's going to throw it out and they're going to award you your attorney fees for the inconvenience. Now, the statute also says at the very beginning, this section is to be construed broadly. That's because when the statute was first enacted, like in 1992, it was toothless and courts were construing it very narrowly and finding a lot of stuff to be unprotected that really should be protected activity. And so the legislature amended the statute roughly 1998 and said it's supposed to be construed broadly. Because of the immediate appeal, I think a lot of appellate courts are still not very open to the idea of construing it as broadly as the legislature, in my opinion, intended. And so there's still a lot of constraints on it. Well, why else should you care? Okay, your case isn't a big company trying to build something in the neighborhood. Why should you care about anti-SLAPP? Well, because it's expanded a lot since then. As you're going to see in my presentation, there's a lot more kinds of claims that are covered by anti-SLAPP. But, for the claims that are covered, when you do see an anti-SLAPP motion, I think you should care a little bit about this discovery freeze. It's in section 425.16G, and it freezes all discovery, pertaining to the SLAPP claim. Now, there might be other claims in the lawsuit that are not so related. I think if there's any overlap at all, a judge is going to say, yeah, it's subject to the discovery freeze, because I don't want to see a whole lot of discovery motions until they work that stuff out. If there's overlap at all, don't waste our time and the taxpayers' money trying to sort out discovery disputes. Go settle the anti-SLAPP dispute first. All right. Well, you're thinking, I'm not going to need that much discovery, or, so I don't really care about that. Well, what you should care about too is you're not going to get the discovery you might need to defend against the anti-SLAPP motion. You just filed a lawsuit based on what your client told you, but your client might not have all the evidence you need to support that. You might need to get that discovery. And if you lose, hey, have a look at this slide, right? You're going to pay attorney fees. And, I mean, sometimes judges give you a haircut, but I've seen anti-SLAPP attorney fees that appellate courts have approved extend way into the six figures. Commonly, they're around $20,000 or $30,000. I saw one recently where somebody called me and got hit with a $3,000 attorney fee award. I said, "Don't appeal. It's going to cost you way more than $3,000 to prosecute the appeal. Just be thankful they didn't hit you for more." Okay, so if the party who files the anti-SLAPP motion wins, they are going to get attorney fees. The only question is, can they show a reasonable number of hours and that their rates were reasonable? That's going to be the only question. They are entitled to fees. If they file an anti-SLAPP motion and lose, you can only recover your attorney fees for opposing their anti-SLAPP motion if their anti-SLAPP motion was frivolous. And so, okay, frivolous is going to depend a lot more on prong one. And I know you're eager to hear about the two prongs, and so I'm going to get to that very quickly. Prong one is you have to show that the claim against your client arises from activity protected by the anti-SLAPP statute. There's 4 different kinds of things that are expressly protected. I'm going to talk about all of them in a minute. If the anti-SLAPP motion shows that the claim against your client arises from protected activity, that triggers prong 2, where the plaintiff or plaintiffs have to show a likelihood of success. Now, if the anti-SLAPP motion fails at prong 1, the likelihood of the anti-SLAPP motion being frivolous is going to be higher. If it fails at prong 2, probably not so high, because it's the other side, the plaintiff's burden to show a likelihood of success. The party filing the anti-SLAPP motion does not carry that burden, and so it's tougher to say that their motion was frivolous. All right, so there's this case out there, City of Rockland, the Legacy Family Adventures. That was a recent case that hit, included award of attorney fees for an anti-SLAPP motion the court said was frivolous. There's also City of Alhambra. I commend both these cases to you for your consideration on that topic. Why else should you care about anti-SLAPP? You got a discovery freeze, you got a prospect of attorney fees looming out there. Well, there's also this immediate appeal that I talked about. That's probably the most controversial thing from a judge's perspective, because the appellate courts feel like they've become backlogged with all kinds of appeals. Normally, you have to wait for the end of the case before you can appeal, but here these anti-SLAPP motions are coming out before anybody's even propounded interrogatories or taken a deposition. So, you might think, well, so what? I've handled appeals before. Well, if you have, then an appeal is going to take over a year, and that discovery freeze is going to remain in place during that whole time. So, maybe eventually you're going to triumph, but it's going to be a long way before you get there if you pled your claim in such a way where it triggered an anti-SLAPP motion. And so if you can plead your claim in a way that it doesn't, you're going to, get to where you want to be or where you hope to be a lot faster. All right. So, what kind of claims look, the kind of claims that right away red sirens should be going off in your head, red, alarms should be going off, red alert, a malicious prosecution or abusive process claim. This is really as close to per se protected by the anti-SLAPP statute as anything. I honestly think it could be malpractice not to file an anti-SLAPP motion. to challenge a malicious prosecution or abusive process claim. You'll see why in just a minute. Defamation claims, very common. Now listen, that's not to say all defamation claims are subject to the anti-SLAPP statute, but I would bet there's probably a plurality of anti-SLAPP motions that were successful that challenge defamation claims. That's probably one of the most common claims that gets hit by anti-SLAPP. Interference with contractual relations or prospective economic advantage is also very common, as is infliction of emotional distress. Now, that's a cause of action that alleges either negligent or intentional infliction of emotional distress, not just a prayer for relief, let me recover my emotional distress damages. It's got to be a claim that arises out of protected activity. And so it has to be a claim, a cause of action, say an infliction of emotional distress. Sometimes people will dress up these malicious prosecution claims as an infliction of emotional distress claim and not call it malicious prosecution, but it's there. It's the same difference. So if you see any of these kind of claims, you should really be thinking, I should think about anti-SLAPP. How's anti-SLAPP going to impact this claim? Maybe not at all, but I at least got to think about it and walk through the process. Well, there's also been emerging claims. Like I said, it's not just limited to those defamation and interference with prospective economic advantage claims. It's expanded, I take the credit of the blame. I helped expand it into employment discrimination claims. That Virgo's claim was an employment case. Breach of contract and breach of implied contract cases also have been known to give rise to successful anti-SLAPP motions. You can bring an anti-SLAPP motion in an arbitration, even if you didn't file it first in court. If you file a demand for an arbitration, there are ways to get the arbitrator to hear your anti-SLAPP motion. I don't know if arbitrators are as likely to grant them. As judges, I haven't done an arbitration where it was triggered, but there is a published appellate decision that says that's how it works. Real estate disputes, maybe even inverse condemnation and eminent domain cases. Probate petitions to disinherit in accordance with the no contest clause, those, are really going to be covered. And I'm just going to stop to explain why that is briefly, because if you're suing somebody for something they did in court, which is exactly what a malicious prosecution claim is, that's going to be protected by anti-SLAPP. And if you're filing a petition to disinherit somebody under a no contest clause, it's because they've contested the will or the trust in court. That's protected activity under the anti-SLAPP statute. Entertainment law claims, they're particularly these DESNY claims. If those of you, I'm sure there's a number of you who are entertainment lawyers out there on my webinar, on my presentation today. These DESNY claims, for a long time, they were kind of not so protected by anti-SLAPP, but just in the last couple of years, the California Court of Appeal issued 2 different decisions that really resurrected them. So DESNY claims are very well in the anti-SLAPP arena now. Family law cases, especially renewals of domestic violence restraining orders. I don't want to sound like I brag, but I saw this coming, like 6-7 years ago. And now, just a couple of years ago, there is a published appellate decision out there about how it works in that context. It's kind of a unique case, so it doesn't have broad applicability, but it does kind of confirm my intuition that DVROs can be challenged if somebody's trying to renew a domestic violence restraining order based on what the person to be restrained did in court. That's probably going to be covered by anti-SLAPP. And also civil actions against litigants and their attorneys for litigation-related statements or conduct, either in trial or even in connection with enforcing judgments. All this stuff is, triggering activity that's protected by the anti-SLAPP statute. All right, so now you're wondering, how does it work, Brendan? Don't keep us in suspense. You told us about these 2 prongs, but you didn't go into detail, so tell me more. Well, the statute doesn't really expressly say anything about 2 prongs, but courts have interpreted to say there are 2 steps to the anti-SLAPP analysis. And so it's because it says that a cause of action arising from protected activity is subject to a motion to strike, which is prong 1, unless at prong 2, a court determines that the plaintiff has established there's a probability that the plaintiff will prevail on the claim. And so in making that decision, it's not like a demurrer. It's sort of like it, but it's not like it, because with a demurrer, you can't file declarations. With an anti-SLAPP motion, either side can file declarations. Courts have said you cannot file one with your reply brief. I don't think that's the best reasoned decision, but that is kind of what the courts are saying right now. No other published decision from a court of appeal has disagreed with that holding. So prong one, well, let's talk about logistics first, and I'm going to go back and we're going to talk about two prongs a lot more. You have to file it within 60 days of service of the complaint. Now, as I highlighted in red, the court has discretion to give you more time to do it. When I first started filing these motions 20 years ago, I think courts were more likely to give you that little extra leeway. I think a lot less so now. I think our courts have become, deluged. We don't have enough judges. They're kind of behind. They're trying to keep up. And if they don't have to decide something because you didn't file something on time, I don't think they're going to be as eager to, let it sit. So I'd say when you get that complaint right away, you should be thinking about, does anti-SLAPP apply to this case? 60 days seems like a long time until you're at day 58 and you're only looking at it then. Now, court is supposed to hear the case within 30 days of service of the motion unless the docket conditions require a later hearing. That's almost always going to be the case. I've never heard, maybe once or twice I've had an anti-SLAPP motion heard within 30 days. It's almost never. I had one, a recent one, I think it took about 6 months after I filed the anti-SLAPP motion before we actually had the hearing. Now, the discovery freeze does apply during that whole time, so the case is kind of sitting idle. But, both parties might want to get the thing going and get to figure out what's going to happen next. So you're going to be waiting for a while. All right, what is a complaint? Well, Brendan, I do family law, I do probate. They don't have complaints, they have petitions. Well, for purpose of anti-SLAPP, a complaint is a cross-complaint, a petition. A plaintiff includes a cross-complainant and a petitioner. A defendant is a cross-defendant and a respondent. So take it from me, courts have construed these terms very, very broadly. I mean, that's right there in the statute, but this Shepherd case that I cite here says, even an arbitral form, that's not a complaint, that's not a petition, it's kind of a demand for arbitration. They say, nope, that triggers it. You can file an anti-SLAPP motion there too. So it's not just routine civil actions. It can go into probate, family law. So far, it cannot extend into criminal law, but I don't think it'll go there. But other things that it can get into. Now, there's 60-day deadline. You should be thinking about it right away. If they file an amended complaint, it's only going to restart that 60-day deadline if they allege something new in the amended complaint that wasn't in the original complaint that leads to anti-SLAPP scrutiny, that alleges some activity that's arguably protected by the anti-SLAPP statute. So California Supreme Court decided this case just a few years back. Newport, again, all these cases are in the handout, so you don't have to scribble them down before I advance the slide. All right, so 2 steps. You heard me say it a few times now. By the end of this presentation, you should be thinking about the 2 steps and the first step in particular. Okay, that should be one of the big takeaways. There's 2 steps. The first step is you have to establish a challenge claim arises from protected activity. And the second step, if the defendant shows that the claim against him, her, or it arises from protected activity, that shifts the burden to the plaintiff to show at the very early stage a likelihood of success without the benefit of discovery. You can get discovery. I'm not going to go into detail about that if you file an ex parte application right away and you can prove I need this discovery and there's nowhere else I can get it. Even then, courts might not be so generous about it. They might really constrain the discovery you're going to get. And a lot of time they're going to deny it. If you wait until you file your opposition brief and say I need discovery, you're too late. Okay, so assuming that the defendant shows the prong 1 arises from protected activity, it shifts the burden to the plaintiff to show a likelihood of success. And that's this California Supreme Court case. It's very important. Barral, it kind of changed a few things that had been thought widely before. Some say for the better, some say for the worse. We'll talk about that in a minute. This second step is a summary judgment-like proceeding. So you get to file declarations, and you don't have to prove conclusively you have a likelihood of success if you're the plaintiff. All you have to show is there's a triable issue of fact, basically. If there's a conflict, you're the plaintiff and you say, he did say these things that are defamatory and false, and my client was harmed by it. And he says, no, I never said them. Or, well, they weren't really damaged that badly or something like that. Well, that's just a tribal issue of fact. There's a conflict in the evidence. The court is not going to weigh conflicts to resolve. They're going to say, well, all right, there's a tribal issue. We're going to let the claim proceed. So if you're defending against an anti-SLAPP motion, don't forget there's two prongs. Don't just challenge prong one and say it's not protected. It doesn't arise out of protected activity. Take the second step and show that your claim has a likelihood of success. All right. Well, how do I recognize an anti-SLAPP problem? Now I know I need to be thinking about this prong one. And if prong one is there, I'm going to have to figure out how to get past prong two. Well, the statute sets out the 4 different kinds of activities that are protected. And so it's right there in subdivision E. And so E1 says any written or oral statement, any written or oral statement or writing made before legislative, executive, or judicial proceeding or any other official proceeding authorized by law. There's a few of them, peer review proceedings in a hospital to decide if a doctor should retain his or her privileges. That is an official proceeding authorized by law. But we're talking about courtroom stuff now here. And so, if somebody makes a written statement that in front of a legislator, a city council, a county board of supervisors, an administrative proceeding, these are all official proceedings authorized by law. If you're getting sued for something you said or submitted to one of those things per se, well, I shouldn't say per se, it's protected by the anti-SLAPP statute. The claim is going to get thrown out unless the other side can show a likelihood of success at step 2. What else is protected? Well, E2 says not only things you actually say in one of those official proceedings or writings you submit in one of those proceedings, if you're talking about them, if you're talking about an issue that's under consideration in an official proceeding, but you're doing so outside the proceeding, that's also protected. It's a little bit like the litigation privilege in Section 47B of the Civil Code, but it's not quite, well, it's a little broader. The privilege is actually a little bit narrower because the privilege you actually have to have a litigation purpose in mind. Whereas this, if you're just talking about it, it's not to achieve your litigation goals. You're just talking about an issue under consideration in an official proceeding. That's protected by the anti-SLAPP statute. You've conquered prong 1. The other side is going to have to show likelihood of success at prong 2. What else? Well, subdivision E3 says any written or oral statement made in a place open to the public or in a public forum in connection with an issue of public interest. And then you have subsection 4 that says any conduct in furtherance of the exercise of the constitutional right of petition or free speech if it's in connection with an issue of public interest. All right, so the first 2 prongs, anything that happens in court or related to something in court, going to be protected. 3 and 4, well, something that's not going on in court at all, but it's a matter of public interest, or it's conduct that furthers some kind of activity regarding a matter of public interest. Well, I think jurisprudence has made E4 kind of overcome E3, and I'll talk about that in a second. But first, let's talk about what is a matter of public interest. There's a lot of cases out there that talk about this. Some of them are going to give you really good guidance, but if you put a couple of them together, sometimes things get cloudy all over again. So you got this C-League v. Infinity Broadcasting case. That's a really good example. You had a TV reality star who these 2 radio guys, these radio jocks, talked about, and she sued them, and she said they defamed her. And so they filed an anti-SLAPP motion, and they said, well, her participation in that show is a matter of public interest, and the Court of Appeal agreed. But then you have this Bernstein case that says, well, a defendant's celebrity status on its own is not sufficient to render anything the defendant says or does subject to anti-SLAPP protection. Now, some folks get a little confused by what I'm trying to say about this other case, this consumer justice case. Let me just say at the outset, I'm not saying anything about a woman's breasts are a matter of public concern, okay? Don't misunderstand me. But this case says a dietary supplement's ability to enlarge women's breasts as an allegedly safer alternative to surgery is not a matter of public concern. So listen, I'm not saying again that, a woman's appearance should be a matter of public concern. I'm saying if a woman is considering a surgery or some other alternative, and there's a whole lot of women out there that are thinking about these 2 alternatives, I'm not sure that's not a matter of public concern, but the court said it's not. And so I'm not sure if that's less of a public concern than whether or not some reality star performed well on a reality television series. But that's just, how I see it. The point is, there's a lot of different things that can be a matter of public concern. There's tons of cases out there about it. Be prepared to do some reading. If you think you're talking about a matter of public concern, it doesn't have to be a concern to the whole state or even the whole city. A homeowners association election is a matter of public concern for that home people who live in that homeowners association. There's a published decision out there about that. All right. Is subdivision E4 is broader than E3 because it doesn't require a public forum. And so this Terry v. Davis Community Church case to me kind of says you don't really need a public forum at all. And so E3, as long as you're talking about something that's a matter of public concern, you can be doing it one-on-one at the water cooler at the office. And it's probably still going to be protected by the anti-SLAPP statute. Maybe not quite that far, but this Terry case does kind of minimize the public forum requirement a little bit. Okay, so if you get into an E4 case, there's not a lot of cases out there, but there is one that is very much worth considering, this Filmoncom Inc. v. Double Verify case. It strives to kind of set out what is a matter of public concern and how closely does that concern have to apply to what's alleged in the complaint. I could do a whole 1 hour presentation about this one case, so I'm not going to go into a lot of detail about that. You just need to know if you're suing somebody for something that might be considered a matter of public concern, or if your client is being sued for talking or writing or doing anything to further something that could be a matter of public concern. You should be thinking about anti-SLAPP scrutiny and reading some of these cases. All right, what if somebody alleges both protected and unprotected activity? A defamation claim. You allege they defamed me in court on the witness stand, and they also defamed me at the grocery store talking about something that didn't have anything to do with the court case. All right, so you got a mixed cause of action. It used to be that if the plaintiff can show that they can establish a defamation claim at prong 2, then the whole anti-SLAPP motion gets denied. But this Baral case said, no, you don't do that. You focus on the allegation that gives rise to prong 1. It arises out of protected activity. And if the plaintiff cannot show liability on that allegation alone, then that allegation gets stricken, basically. The other allegations might still survive, but the defendant has prevailed on the anti-SLAPP motion and can recover attorney fees for striking just that one allegation. Depending on how big those attorney fees can be, they can amount to leverage to get the plaintiff to dismiss the rest of the claims in exchange for compromising or waiving the recovery of attorney fees. All right, so the definitional focus of anti-SLAPP is it's not limited to defamation, it's not limited to malicious prosecution, it's not limited to interference with prospective economic advantage or infliction of emotional distress. It can cover just about anything so long as it arises out of E1, E2, E3, or E4. If it alleges somebody is liable because they said something in court, either in writing or orally, or because they said or wrote something about an issue that's under consideration in court or an arbitration or a legislative proceeding or any other official proceeding, or they're getting sued because they said or wrote something about a matter of public interest or a matter of public concern, or they engaged in some kind of conduct that's really somehow tied to a matter of public interest to further free speech and petitioning rights, well, then prong 1 is triggered and the anti-SLAPP motion, the anti-SLAPP statute applies. It doesn't matter if it's family law, probate law, arbitration, any kind of civil claim, real estate, business, contract, tort, whatever. You're probably going to be looking down some anti-SLAPP problems, anti-SLAPP engagement. All right. So I want to pause now. I told you I would when I get a little over halfway through and you have an understanding of how the statute works a little bit to answer questions before we go into these hypotheticals. And so let me glance and see if we have, do I happen to know if the legislative intent of the California anti-SLAPP statute contains any reference to heated series of litigation among members of the bar in the Central Valley, as covered in the 60 Minutes interview of Ed Freeberg by Charlie Rose, aired on national TV during the 90s. Ed Friedberg, probably dealt with a lot more anti-SLAPP statutes than almost any attorney I know. For those of you who don't know him, Ed was a very successful businessman who, according to the Wall Street Journal, if I'm remembering correctly, uh, was so angry at his at his second wife's attorney in his second divorce that he went to law school and decided he was going to sue lawyers for bad behavior and was wildly successful at it. And so he filed a lot of malicious prosecution claims, which per se are going to be covered by anti-SLAPP. He also filed a lot of malpractice claims, legal malpractice claims. I can't say they're never covered. I'd say, though, they're not nearly protected by anti-SLAPP as malicious prosecution claims. Isn't it now in the trial court's discretion to grant an anti-SLAPP motion? Well, they sort of have discretion. Attorney fees are definitely in the trial court's discretion, but on appeal, if you say the anti-SLAPP motion was wrongly granted or denied, that's not an abuse of discretion standard. That is a de novo standard. And so attorney fees are in the court's discretion. Whether or not to grant the motion, not so much. Would you please expand on Bassi holding that some emails form the basis? Yes, that's in my handouts. That is the case that deals with domestic violence restraining orders. Those emails and their protected status, some went one way, some went the other. I'm afraid that's a little more than I have time for. If you want to contact me after the presentation, I'd be happy to talk to you about that there. Does a denied anti-SLAPP set the tone for a motion for summary judgment later? No, I don't believe so. An anti-SLAPP motion, it's like it gets granted or denied on one particular kind of basis. If you probably better have new information, though, if you're going to file a motion for summary judgment that's based on the stuff that was already adjudicated in an anti-SLAPP motion. If there's a triable issue of fact in the anti-SLAPP motion, it's very likely on MSJ the trial court's going to find another triable issue of fact, unless you have something new and you can combat that. Renewal of DVR and anti-SLAPP. Okay, I'll cover that really quickly. I think it's in the hypothetical also. You get a domestic violence restraining order, and it lasts for 3 to 5 years typically, and then you can renew it. If you're the protected party, you can go back to court and renew it. You go back to court to renew the restraining order, and your allegations say only, when I got the last restraining order, my ex stood there in court and said he didn't do any of these things. He said that I'm making stuff up. He lied, and he resisted it. He resisted the restraining order. And so therefore, he's still a threat to me because he's not acknowledging that these things really happened. Or he filed an appeal. Better yet, he filed an appeal challenging the domestic violence restraining order. Those are all protected conduct. That is protected under anti-SLAPP E1. You're talking about things he said or filed in court. That's protected under E1. Eddie Mahoney, can you explain what conducted lended to application of anti-SLAPP success? Well, I'm not going to get to the hypotheticals. You all have a lot of really great questions. So Eddie Money was a rock and roller who, may he rest in peace, had a lot of great hits that got me on the roller skating rink whenever they played Two Tickets to Paradise. He had a drummer who was with him all those years, and his drummer got cancer, and they went on tour, and Eddie didn't take his drummer on tour with him, and his drummer sued for employment discrimination, basically failure to accommodate disability discrimination, and Eddie Money filed an anti-SLAPP motion and prevailed because that's First Amendment choice. If he's on a stage, he gets to decide who's going to be on stage with him because he's trying to send a message out to the world and he gets to control that message. It's a very nuanced case, but that arises under a matter of public concern sort of analysis. That's like an E3 or an E4 analysis. Party A files a civil rights lawsuit against Party B. B's attorney takes actions in court which Party A believes are retaliatory for filing a legal claim. If Party A files a suit against Party B for retaliation, anti-SLAPP, how does anti-SLAPP handle claims alleging retaliation? Well, retaliation in that scenario to me sounds like a malicious prosecution claim being called a retaliation claim. You're suing somebody for what they did in court. It's protected under prong one. Prong one, you're suing them under 425.16 E1. You're suing them for things they said and did in court. They have an anti-SLAPP motion. they might be able to assert a privilege at prong 2 and succeed on the anti-SLAPP motion. Are there jurisdictional issues to be aware of prior to beginning an anti-SLAPP issue? Deadlines to meet and confer requirements? No, there is no meet and confer requirement. You don't have to meet and confer on an anti-SLAPP motion. You have a 60-day deadline to file the anti-SLAPP motion. That's not jurisdictional, but in my personal experience, it's anecdotal, but I think courts are less and less likely than they were 15 years ago to give you an extension of time to file your anti-SLAPP motion, so be aware of that. Okay, does anti-SLAPP apply in federal court? Laugh out loud. Yes, but we're not going to talk about that. It does apply. A recent case holds that a request for domestic violence restraining order filed in a pending dissolution case is a motion in that case. Okay, but the Domestic Violence Prevention Act allows one to file a request for such a restraining order. Separate case. Oh boy, this is kind of a long question. Listen, I'm going to ask you, Suzanne, I'm going to ask you to call me about this afterwards. I think it's a great question, but I really want to focus on things that are going to help people understand sort of in basic terms everything, and this is kind of nuanced. So I'm going to try to get to that. If you call me or you email me, we'll set up a time we're going to talk about this. All right, I think that covers all the questions, and so now I'm going to jump into hypotheticals. And if there's, I got a lot of them. I got more than we have time for, but I'll probably try to stop early and see if there's one or two more questions I can answer. So moving to the hypotheticals. Hypothetical number 1. Virtueless vixen, Vivi, is plucked from obscurity to compete in a popular reality television show. You heard me talk about this already a little bit. She openly appears on a few episodes before she's disqualified. 2 widely heard radio talk show hosts, let's call them Russ Lowbrow and Hapless Spurned, discuss Vivi on the air, and they explain why they think it was right to disqualify her. Spurn calls Vivi a skank, while Lowbrow reports that people are saying that she's a member of both Antifa, the Proud Boys, and NAMBLA. Wow. What a membership. Vivi sues Lowbrow and Spurned for defamation. All right, if Lowbrow and Spurned file an anti-SLAPP motion, will they prevail? Okay, so listen, I know you'd have to type your answers, and so we're probably not going to have a lot of time for typing answers. And so let me just try to, we'll cut to the chase, right? Instead of keeping you in suspense. They probably will prevail on prong 1, and really that's what my presentation is about. If you're seeing a prong 1 problem, you should think about how to recraft your complaint so that you don't get into anti-SLAPP trouble. On the other hand, if you get a complaint and you see a prong 1 issue, we're off to the races. You're going to freeze discovery. And not only are you going to freeze discovery, when the other side has to show a likelihood of success, they're going to have to give you probably the best evidence they have to avoid having their claim dismissed. You're going to get all kinds of free discovery without propounding one interrogatory, without, trying to, synchronize your deposition so that you get to the questions in the right order and get the aha at the end. You're going to get that right out of the gate. All right, so they'll probably prevail on prong 2. We're not going to talk, like I said, a lot about prong 2, but it's skank is kind of an opinion rather than a demonstrably false fact. Lowbrow might have a harder time because membership in one of those organizations is probably provably false, true or false. So the C-League case covers that. Again, it's in your materials. So prong 1, red alert, right? You got to think about, how am I going to beat prong 2 if I'm going to keep this allegation in my complaint or petition? Number 2, prim plaintiff propounds written discovery to dastardly defendant in a breach of contract case. Dastardly's discovery responses reveal facts indicating that he may have used misrepresentations to induce Prim to enter the contract. Based upon those discovery responses, Prim moves for and obtains leave to file an amended complaint to include a fraud claim. Prim's amended complaint alleges that he discovered the fraud through Dastardly's responses to written discovery. Okay, based on this, can Dastardly file an anti-SLAPP motion? To strike the fraud claim from the amended complaint. And let's assume the 60-day deadline is fine. It's an amended complaint. It's new. Well, that's an unfair trick question, everybody. Yeah, you can always file an anti-SLAPP motion. The question is, are you going to be tagged for filing a frivolous anti-SLAPP motion? If you file a frivolous one, you're going to be on the hook for attorney fees. Now, as I said earlier in the presentation, if you can beat prong one, you're probably not going to, face liability for filing a frivolous anti-SLAPP motion, even if you lose at prong two. Okay, now here the claim in question was merely triggered by information that was developed in discovery. The discovery proceedings, themselves are not a fact that has to be proven to establish liability. Now, you might have to prove, that you discovered the fraud only because of the discovery responses, because they might have been barred by the statute of limitations, but because you didn't know about them, you got the discovery rule. And so, um, that makes it a little more cloudy. I haven't seen a case that addresses that. But if you're just learning something from discovery, you don't even have to allege it in your complaint, really. You don't have to say, I found this out through discovery, unless you're trying to stay within the statute of limitations. So that's a good example of thinking, do I really need to keep this? Because if you do, you're going to face an anti-SLAPP motion, but maybe you can beat it at prong two. You just have to have your ducks in a row and figure out, do I need to get other evidence to beat the anticipated anti-SLAPP motion? Hypo number 3, prim plaintiff propounds written discovery to dastardly defendant. Sounds familiar. In a breach of contract case this time. Dastardly, snarky, and insulting discovery responses deeply trouble prim. Based on those snarky and insulting responses, prim files a separate lawsuit asserting an infliction of emotional distress claim. This new lawsuit alleges that reading those snarky insults caused prim emotional distress. Can dastardly file an anti-SLAPP motion to strike the emotional distress claim? Well, you're all gonna, you remember from the trick question last time, you can always file it, so you're not going to fall for it this time. Yeah, Brendan, we know you can always file it, but the question is, can it beat prong one? Can it surmount prong one? In this case, I think such a motion is more likely to succeed because, unlike the previous one, it's protected litigation conduct. You're answering a discovery response. That's litigation conduct. That's E1. If it's not E1, it's definitely E2, but I think discovery responses are going to be in E1. And so it's protected litigation conduct that gives rise to alleged liability. And we're not going to talk a lot about prong two, but Section 47 of the Civil Code comes up a lot in these cases, the litigation privilege. I think that conduct is likely privileged there too. Hypothetical number 4. Good Citizen Choo Choo Train Company is a non-governmental nationwide railway. I'm going to skip that one to get some other ones that cover stuff that is more, I don't know, help you understand how anti-SLAPP works a little bit better. That one's a little nuanced. Here, let's talk about Disney a little bit. I'm using some names of some lawyers that work at my firm just for fun, in case any of them are watching. Jessica Marlowe develops an idea for a reality television show called Brendan's Big Adventure. It's about a nerdy appellate lawyer who rides his clunky bike around Sacramento. He's looking for anti-SLAPP appeals, and he meets attorneys along the way who are more interesting and sensible. Some of you out there might be old enough to remember Pee-wee's Big Adventure. Jessica visits Hervey Studios to discuss the idea. After she fulfills Hervey Studios' request to draft a more developed screenplay for the pilot, they enter an agreement to try to launch a show that if they can find financing. Shockingly, that financing never materializes. All right, well, Hervey Studios later partners with big-time film financer Wayne Kazan, and they're going to make a successful show called Z. Smith's Big Adventure. Z. Smith happens to be a lawyer here too, gee. Well, it's about a dapper lawyer who swerves his snazzy electric car into bike lanes around Los Angeles, shouting slurs at nerdy appellate lawyers who are riding in the bike lane. Well, Jessica gets no credit or money from Hervey Studios in connection with Z. Smith's Big Adventure, which is a big success, and she files a Disney claim against Hervey Studios alleging breach of implied contract. In other words, she's claiming that Hervey Studios impliedly promised but failed to compensate and credit her if they used any element of Brendan's Big Adventures in one of their projects. How good of a chance does Hervey Studios have of getting past prong one of the anti-SLAPP challenge to this Disney claim? Well, before last year, not so good of a chance, but now a very good chance. The California Court of Appeal came out with a couple of cases. The one I commend to you that's cited in your materials is Norman v. Ross. It resurrected these Disney kinds of claims and said, yeah, they're covered by anti-SLAPP. because it's a matter of public concern. Basically, E3, these TV shows, it's First Amendment protected activity. You're putting this creative stuff out there. And so, there's a lot that goes into the creative process. And so it's probably going to be covered by anti-SLAPP. Got time for maybe one more. Let's give it a shot. Discriminatory defendant, a public entity, files, they fire, sorry. Discriminatory defendant, a public entity, fires protected class plaintiff from his job after discussing at a formal but closed door board meeting whether to promote protected class plaintiff or terminate him after he complained about misuse of public funds and sexual harassment by his slimy supervisor. PC files a lawsuit alleging employment discrimination, harassment, and retaliation. Do any of these claims allege conduct that is arguably protected in the prong one analysis? Real fast, prong one. Is statement said in court? No. Is it a statement about a matter under consideration in an official proceeding? Gee, maybe. It's a public entity and it's a formal meeting, but it's a closed door board meeting. That could be an official proceeding, right? And so, well, let's see. Public employment aspect does tend to make claims more susceptible to anti-SLAPP attack under E1 or E2 because it's an official proceeding, at least potentially. There's two cases that govern this, one of them is mine, one of them is a California Supreme Court case. They kind of go hand in glove. Virgos, my case, Virgos says, a public employee who's processing these grievances and adjudicating them is engaged in, protected conduct under E1 and E2. And the Park v. Board of Trustees kind of adds some nuance to that, but some direction also. It's difficult to convince courts that employment matters are of public concern if it's private sector, especially. So if it's just a routine garden variety employment dispute, this Rivero case, in my opinion, does not take into consideration the broad application it should have. I think it construes protected activity a little narrowly than I would have if I were the judge, but it's out there. It's not been reversed, so you need to know about it. Okay, let's see. I got to get to the 1:30 mark so you all get credit, so I'm going to try one more. I don't see any questions in the Q&A, so I'm just going to keep going so that we get you all the credit you need to endure my presentation. Discriminatory defendant, a television broadcaster, refuses to hire protected class plaintiff as meteorologist and instead hires a younger female for the job. Just down the street in Media Land, Tommy Tone Deaf defendant, a rock star, fires his recently cancer-stricken percussionist, afflicted drummer Aldo. Sounds like something we already talked about a little bit. PC plaintiff and ADA plaintiff file lawsuits against DD and TDD alleging age, gender, and disability discrimination. If discriminatory defendant and Tommy Tone Deaf defendant file an anti-SLAPP motion to strike, will they be able to show that any of those claims arise from protected conduct? I kind of already told you about this one. Yeah, most likely. You have the Hunter case, which is the meteorologist case decided by the Court of Appeal, and you also have Simmons v. Mahoney. You might not recognize Mahoney. That was Eddie Money's real name. And if he stayed in a hotel, you'd have to call and ask for Edward Mahoney's room. But Eddie Money, that's the Eddie Money case where he fired his drummer. You also might want to look at Wilson v. Cable News Network, again, in your handout, so you don't have to scribble it down. That's California Supreme Court case. California Supreme Court has talked twice about employment law anti-SLAPP. So that's an active part of anti-SLAPP. I see two questions in there before we try to tackle another hypothetical. Let's see. Does First Amended complaint trigger anti-SLAPP all over again? Only if the protected conduct was not alleged in the original complaint. If the amended complaint includes a new allegation, the 60-day time limit starts ticking again. Sometimes if they file a First Amendment complaint within the 60-day time limit, they're re-alleging that same thing. Yeah, if you're in the 60-day deadline to file anti-SLAPP motion, go for it. Oh, let's see. Jack Russo, isn't discovery stay during an appeal now in the trial court's discretion? Well, it's in the trial court's discretion whether or not, the claims overlap. If a new case came out and I'm not aware of it, I'm going to have to go take a look at it. But my last recollection was the California Supreme Court case in that Vivian, was it? I'm trying to remember the name of it. It's in your handouts. It begins with a V, and it says the discovery stay remains in place during the appeal. Forgive me if there's a new case that I've overlooked. The trial court has some discretion to say whether or not the claim, the discovery in question is covered by the claim that's challenged by the anti-SLAPP. But if it's related to that claim, discovery is going to stay frozen during the appeal. You said Supreme Court only has 2 anti-SLAPP and employment suits. Do you mention these? Yes, they're both in your handouts. One of them is on this last slide, Wilson v. Cable News Network, and one of them is on the prior slide, Parker. Let's see, what was it? Park v. Board of Trustees. Okay, we're right at the 1:30 mark right now, so I'm not going to start another hypothetical. You guys got full credit. They're all the other hypotheticals are in there if you want to read them and get some ideas about how it might apply to some of your cases. If you have any questions, follow-up questions, by all means, please call me or email me. I am happy to talk about anti-SLAPP all day long. You'll spare my girlfriend from having to listen to me talk about it to her. With that, I'm going to conclude. I want to thank you all for coming. Remember, be on the lookout for prong 1. Thanks so much.